Hi, everybody. This is Kimberly Banks Fawcett, and you are with the DFW Note Closers Group. This is our April 2019 meetup, and we are going to be talking tonight with Daniel Singer of the Singer Law Group. We are going to talk about lost MIT, something that every note investor needs to understand the concepts of and who to go to for help. Even if you invest in just performers and reperformers, eventually you're going to have a note that stops performing, and you're going to need to know what to do with it. Then when we get to the Q&A part, I've already warned Daniel that I have a couple of questions on BK seconds, so veering a little bit off of the lost MIT process, but you know, that's the kind of thing I do. So without further ado, here is Mr. Daniel Singer.
Well, thank you, Kimberly, for having me this evening. Thank you, everybody. As Kimberly said, I'm Daniel Singer. I'm the managing partner of the Singer Law Group. We are a Southern California-based, I like to say creditors' right firm, meaning that we exclusively represent note buyers, servicers, banks, in various troubled loan situations, from bankruptcy, foreclosure, here in California, Nevada, and then we have a national bankruptcy practice. So if you're buying a loan, let's say in Wisconsin, Ohio, Minnesota, and you have a bankruptcy situation and you need us to file a claim, proof of claim, transfer of claim, we can handle that as well. Sort of a little bit of background on myself. Like many of you, I started off as a note buyer, actually in seconds. I was practicing law, had some opportunity to buy a portfolio of seconds. I timed it perfectly with the crash of the market, and so my seconds became unsecured seconds rather quickly. But in that process, I learned a lot, mainly by my own frustrations, in that when I was buying notes and trying to foreclose on that, I was struggling to find attorneys that were sort of like-minded, like myself, and that they're not just there to sort of bill fees. So with the help of a default legal network that I'm part of, George Caballero, we can handle foreclosures and bankruptcies and all loss mitigation matters basically throughout the country. Again, with a group of attorneys that understand that, like you, it's speed to liquidity. So moving that asset in the direction that you need to liquidate it as quickly as possible is key to the success, key to keeping your investors happy, and sort of allow you to redeploy your funds. So we get a lot of various requests here for loss mitigation work. Most of the time, you've acquired a loan. You need a little assistance with your servicer to do just a little bit of outreach. So we supplement a lot of times with the servicers where they're performing their basic necessities as a servicer. There are 2 or 3 calls every 2 weeks, their letters, and then we just supplement that. So we have a full in-house call campaign team here, making each person anywhere from 150 to 200 calls a day. We have a letter campaign that we will work on with you to determine what's the best course of action. And then we usually revisit that every couple of weeks to determine whether it's working or whether it's time to escalate to something else or change strategies. We have a nice back-end portal, just like the servicers do, where you can see everything that we can see. So any calls, emails, borrower contact, letters that are going out, letters received, communications with attorneys, milestones, it's all updated in our system. You can access it in real time. And of course, we're always available as well for calls, emails. We email every milestone, etc., as to any new developments with your loan. As you'll kind of, for those clients that have worked with me, I'm a big believer in, I keep everything on a very short leash. And so unlike, some of the servicers where, hey, let's spend the next 90, 120 days to really try to get these borrowers on a loan modification, we're a big believer in using foreclosure as a tool to encourage consumers, borrowers to contact us. I say that not that I don't actually intend to foreclose. We tell all of our clients that when you start the foreclosure process, you cannot start it solely as a threat, but you always have to intend to proceed through foreclosure. But if by the time you get to me and the servicer or your successor or your predecessor in interest has called a borrower 500 times, sent letters, no response, the likelihood that another letter, another call is going to get anywhere is probably not great. Does it help to have a law firm? Absolutely. Um, but we are a big believer in using foreclosure again. And so we like to push our clients. And when we talk to our clients on that sort of onboard interview, we always say, understand that foreclosure is the likely outcome here. And sort of be prepared that you have those funds available, that's the process that you and your investor or you are going to have to pursue. And as we know, foreclosures in most states don't go as we all anticipate. And, if it says 3 months, it's usually double that. If it says it costs $3,000, it's usually double that. And so we go through all of that with you. And we sort of, as part of our plan, say, hey, in this state, here's our experience. Here's the estimated timeline. Here's the estimated costs. We'll introduce you to the firm that we use. You engage that firm directly, and we manage that process. So what does that mean? It means that we gather all of the docs necessary to get that process moving, from complaint through foreclosure sale. As stuff comes up, they need figures. They need to know what direction that you want to go out of hearing. They need somebody to respond to a borrower inquiry. They need you to make an appearance at a hearing. We manage all of that process for you. And it's doable with one loan, but as you grow your portfolio and you have one in Wisconsin and one in Florida, and then you got another one in Indiana and New York, it's hard to get bombarded with emails from attorneys every day saying, hey, I need you to respond to this. I need a direction from that. And as fortunately as we know, attorneys, some of the emails tend to be a little technical and it's confusing. And then to try to get them to explain it all causes delays. So that's kind of what we do is we coordinate with all the counsel across the country. We are your single point of contact for all legal issues. And we make sure that process moves. If stuff needs to be, obtained from you, we kind of put it in a sense that makes sense, that's digestible. We get right to the point of, hey, this is what we need from you. Here's the likely outcome. And then, we're there to consult you and based on our experiences, litigating matters as well as note buyers as well. We like to sit with clients and say, hey, this is one of the situations you just got to cut bait, or this is something that's worth pursuing. In our experience, here's the potential outcome and risks that are there for you. And that all encompasses in our monthly fee that we charge, versus if you sat on the phone with the attorney on an hourly billing rate, it could get quite substantial rather quickly. And then if a bankruptcy arises, and in many cases it does, again, we can handle the claims work. So we'll file your proof of claims. We work with your servicers to file the transfer of claims, the notice of payment changes, all of that. If a default occurs during the bankruptcy process, we can handle the overseeing of the motion work to get the stay lifted so you can continue with your state court action. So kind of a high level, that's what we do. We have a team here of about 6 now. And again, we're available all the time for our clients. We try to point a single point internally at the office that usually works the file, so you're not jumped around from one asset manager or one attorney to another. And I oversee, for the most part, all of the files, so I usually have a good grasp of what's going on with your files. So that's us.
Well, we've used your firm on a number of deals and have always had a great experience. How does it work if we're coming to you after we've already done some work in a particular market and we already have an attorney there that we like and they're not in your network? Can you be that liaison with different attorneys?
Yeah, absolutely. I mean, we're open-minded to an attorney that you have a relationship with. Okay. Of course, it's always preference to work with our own attorneys, but if you have a relationship with somebody, we're happy to use them on your matter. We'll get a call from a client that says, hey, I bought this loan. I'm in the judgment stage of a foreclosure process with this firm that I really like, and I'd like for you to take over the management. And my first response to that is, well, why would you want me to take over the management of that? If you have a firm that you really like, and they're doing a good job for you, maybe you don't need me, at all. And it's not uncommon nowadays for us to tell clients, hey, this sounds like a situation that you have under control, right? And the reason I say that is because, you know, costs matter nowadays, right? And so if I can save you a couple bucks just by saying, hey, look, you're in good hands. I know that firm. They're going to do great by you. They're great communicators. You'll have no problem with them. Then, we're the first people to say that. But of course, if you have a relationship with the firm, we're happy to work with them. And we've worked with just about every firm out there. There's not many firms that we don't know or we haven't worked with.
That sounds like a challenge. I want to go find one you haven't heard of now.
Yeah.
Well, actually, the first time that I ever called you for help on a loan, the first thing you did was refer to me to someone else because it was in Reno.
Right.
And that wasn't
That's
your
right.
place. And
Yeah.
yeah,
I mean, you have to be not only mindful of where you're buying, of the firm, but you got to be mindful of where you're buying. And, if you're buying in small town America, and, it helps to have a law firm in that small town that you're using. So, that's some of the process that we go through with the clients to say, hey, look at, we strongly recommend this firm, not because they're the biggest, baddest, or best firms, but they have familiarity with that market. They'll know the judges, they'll know opposing counsel, they'll be able to move that process far quicker than, some firm that has one office 2 hours away in a big city.
gotcha. So they do have local experience that you might not have. But what do you do in a situation where you just wouldn't go in the direction that attorney is choosing? I mean,
Right. So at the end of right. So we'll tell you, based on our review of the file, it's our opinion that there's a better or more preferred, route to go. And we'll make a recommendation. And we may say our recommendation is you pull the file and you go with a firm that we've had a good experience with, that we know will go in the right direction. But at the end of the day, you are the client, right? And you're the ultimate decision maker. And if you have a firm, again, that you like, and, that's your relationship with them, you've engaged them. And so we would never tell you, hey, this has to be done. Again, you are the ultimate decision maker of your direction of your case.
okay.
And we'll always give that, well, we're not responsible for the outcome, right? Typical lawyer, disclaim.
If you're not going to listen to me, then I can't
Right.
help you, and whatever happens, yeah.
Very early in my career, I had a lawyer that said it's the practice of law, right? It's the practice of medicine. You can get two great attorneys together in a room, and both of them will disagree with the direction it's going. So
Yeah.
I may say, hey, this is the direction I would go. And it may not be the right direction, or it may be, but another firm may say, no, this is the direction we're going to go.
Okay.
You try to figure out somewhere in between that's a compromise. But nobody's perfect.
No, nobody's perfect. So give us an idea of a case that you worked on for a client that went really, really well, and one that no matter what you tried, it still went to hell.
Oh man. I just had a big foreclosure in Los Angeles on a sober living facility.
Oh.
Word to never buy loans on sober living facilities. Besides the fraud that was being committed by the borrower to try to evict, 25 tenants, it was a tough undertaking. And especially nowadays, like, for example, if you're buying in Oregon, and I know there's some changes there on rent control. We have rent control in various cities throughout California. Obviously, New York has it as well. So a lot of people buying, mortgages, they foreclose. There's a borrower in there or a tenant in there, say, great, we'll get them out. And it's like, well, no, you're living with that tenant because rent ordinances in that community. So we deal with this. This one was one of those situations in multiple bankruptcies. It took us about 1.5 years to complete just the eviction.
Wow.
And in California, the average eviction is about 60 days. So you could see that to try to explain to a client that, 60-day timeline is going to extend to about 1.5 years. I mean, it's, that's a big financial pill that somebody has to swallow and pay for that along the way. I never really say there's an outcome that's a great outcome because, to me, a win is the client forecloses and they get the house back. But to that client, that may not be a win, right?
Mhm.
So the win is whatever our clients decide is a win. So, we have a lot of clients that they'll get into a very contested litigation case and it turns to a loan modification. It's a win for the borrower and that they can retain that property and keep that house and they don't have to be displaced. And it's a win for our client because they can stop the legal, fees and costs from continuing to occur. And now they have an asset that could have been highly contested that they were able to secure a loan modification. I would say that the majority of contested cases that we deal with end up with a resolution with some sort of loan modification.
Hmm. Why is that? Why wouldn't, I mean,
Well, I think
if
the
they're
struggle in
contesting
the
it,
industry is, the big servicers, because loans are trading, especially on the levels that we're buying it, that we're seeing them, right? They're trading so rapidly. And, a lot of the servicers, because of service transfers and new owners, there's not that time that it takes to say, hey, could somebody actually reach out to the borrower and figure out what they really want to do? And then lawyers get involved. And then once lawyers get involved, we try to overcomplicate matters uh, and it's just no cooler heads just prevail and just sit down and say, at the end of the day, you have a house that you want to retain. And I have a loan against your house that ultimately I'm going to foreclose on, right? I mean, nobody gets a free loan for the most part. So I'm willing to offer you something that, it may not be the return that I promised my investor, but it's something that's certainly palatable, and it's a win-win. And so we really do push a lot of our clients in those situations to forget chasing yield and just find something that, hey, you know what, I can now take an asset which could have been troubled, right? We have a case now, which, the client had to write a $50,000 check prepared to go to a trial on a house that's probably worth $20,000.
oh,
Where, if we would have just said, at day one, let's just resolve this by way of a loan modification and not shoot for a yield that's 20+%, the whole thing could have been avoided.
yeah. I think sometimes when you're dealing with a defaulted borrower,
Mm.
you sort of lose sight of the end game. I recently, I think it was about 4 months ago, did a forfeiture on a CFD in Dayton because he would not consistently pay. He was spotty paying, but
Mm.
if I didn't complain, he didn't pay. And then he wasn't paying his water bill. And then he
Right.
wasn't, the town was coming after him. And, in a contract for deed, as the lender, I have the deed. So he
Sure.
just became a problem. And no matter how many times we reached out to him, he wouldn't talk to me. He wouldn't
Right.
solve the issue or explain what the issue was. So we did a forfeiture. Well, he was not very pleased about that. He screwed all of the doors and windows shut from the inside, ripped
Yeah.
all of the cabinets out of the kitchen, pulled out all of the electrical wiring. He didn't take it with him though, but then he went out through the garage and then closed the garage door and then drove into it. And then he left.
I've probably foreclosed. I mean, I was doing 500 plus foreclosures a month for one client. And I would say of the thousands and tens of thousands that I've done over the course of, I don't know, 16 years now, I've only had one borrower destroy a house.
Really?
Intentionally, right? There are hoarders, so we do get hoarding situations. There are borrowers that just perform no maintenance on their property, so they just never maintain it. But I've only had one borrower intentionally destroy a house. And so we get a lot of clients that will come and they're very adamant because they hear about these horror stories that, oh, they're going to put cement in the toilets and they're going to rip all the piping. Does that happen? Absolutely. But the majority of the time, they just want to move on with their lives,
Mm-hmm.
right? In a very civil manner, right? A lot of times they have children, right?
Mm-hmm.
They know family in the community, right? So if you can kind of convince them to say, you know what, don't live the rest of your life being tied down by this house that you're ultimately going to lose, right? So maybe we can assist each other where you can just move on with your life, right? Maybe there's some relocation assistance that we can be available,
Mm-hmm.
right? A couple bucks, maybe a moving truck to help them can avoid all of those problems altogether.
I agree. The only problem is
I
he
think
was
the
young.
biggest problem with note investors is they buy a loan with a predisposition of the outcome.
Oh yeah,
So
absolutely.
they buy it thinking this is going to be a modification candidate. And I say, well, it would have been, but you didn't read the servicing comments. And so what you didn't realize is the property's vacant.
Yeah.
Well, I want a loan mod. And I say, I understand that, but the property's been vacant for 10 years and it's been boarded up. And very few borrowers, despite what you hear, are moving back into that house,
Mm-hmm.
right?
Yeah.
And on the other hand, it's, oh, I'm going straight to foreclosure because this house has a ton of equity in it and I want to own the house because I love that neighborhood. And I say, well, that's great, but somebody's living there. And they're just not moving because you bought their loan and you want that house to live in, right? I mean, and they have options available to them, right? They can file bankruptcy. They'll file lawsuits. The plaintiffs' attorneys or the defense attorneys out there, consumer attorneys, are extremely litigious. And as you start moving into potentially the next foreclosure crisis, states understand what happened in the past, and they're not going to allow
Mm-mm.
these just foreclosure epidemics to occur. And when foreclosure epidemics do occur, lawyers figure out a way how to make money from it, right? So you can avoid a lot of those problems by saying, look, I'll go in open-minded. If deed in lieu is an option, great. If I can get a good loan modification that will yield myself and my investor an opportunity, great. If I can do, something else, great.
So what do you think is the best way in that scenario to get the borrower to listen to you? I mean, you can have an idea of all these wonderful things you could do for them, but if they
Right.
won't respond, you're out of luck.
Again, I think as your example is, you start your forfeiture,
Hmm.
you start your foreclosure. And I tell clients, look, it's the means of last resort, but that's the nature of the business as well, right? If you extend the olive branch and they don't, they don't pick up and respond to the invitation to stay, then you know what? Then you start the foreclosure.
Yeah.
And then a lot of times that discussion's a little different. They understand now that you're serious. Keeping in mind that they've probably gotten calls from every servicer that we know because the loans have transferred servicing. They've received calls from Bank of America, Wells Fargo, everybody who else owned their loans. And they all say the same thing, right? And so when you actually start that foreclosure process, they say, well, wait a minute, maybe these people are serious, like they truly are going to foreclose. And a lot of times we get calls and we have to explain to them the nature of the business. They're like, oh, I've received 50 calls and I applied for loan modification and then I don't hear from somebody for 2 years and then so-and-so bought my loan. Right? And so we explain to them, well, yep, that does happen and we've apologized for that experience, but here's how it's going to go in the future, right?
Hmm.
You can apply for this mod. We keep them on a very short timeline as to when they have to receive the loan modification until they have to get it back. We're very diligent at responding. Hey, thank you for your loan modification, but you only sent in your tax returns and nothing more, right? Whereas maybe the bank that bought it before, they'll take 3 or 4 weeks to respond to that inquiry, right? And it's just borrowers. I mean, borrowers understand the game. I mean,
Hmm.
foreclosure people, they can't figure out how to pay their bills, but they sure know how to live in that house for 10 years without paying those bills. So it's just a lot. I mean, truthfully, it's just kind of outsmarting them. And after 16 years of doing it, we've seen most delay tactics, as I'm sure you have as well.
Hmm. Well, when you start dealing with a borrower, there are obviously some that are just overwhelmed by the whole situation and they're not paying
Yeah.
attention and having a very human response. And then there
Yeah.
are other people that are trying to delay the process and they'll
Right.
just send you one paper at a time so they get as much free rent as possible. Is there any kind of indicator when you're talking to these people initially that you can sort of figure out which way they're going?
One is being very diligent, right? So I like to say to when I get somebody on the phone, here's who I am, here's what we'd like to do. Well, I'm suffering from some illness or I have some sick family member, but I'll give you a call back. And I say, okay, well, what time are you going to call me back? Well, I'll call you back 5 o'clock tomorrow. Okay, 5 o'clock tomorrow. At 5:05 tomorrow, if I haven't heard from them, I call them back, right? So you want to establish some sort of, hey, I want to be accountable to you, right?
Mhm.
Because they have no accountability whatsoever. I mean, they're getting calls all day from the Ford Motor Company, from their credit card company, and they're just, clicking it, clicking it. Or they say, I'll call you back, and Ford Motor Company doesn't call them back for 3 weeks, or and then it's somebody else that calls them, and it was like, hi, I'm calling for. So we try to say, yes, Miss Fawcett, we did have a conversation yesterday. You did tell me, so we always personalize it.
Okay.
Because they say the same thing. Oh, I applied for loan modification 2 months ago. I never back. Actually, yes, you did apply for it on this day. We spoke. Remember that we had that conversation? Oh, yes. And I did respond to you on this day with that letter, correct? You did receive that. And it's like, okay, you got me,
Mhm.
right? And then unfortunately, I mean, there's just people that have terrible life circumstances. I mean, and it's, they have valid reasons why they've defaulted. And we'll tell you, hey, this is not a situation where somebody's really just trying to buy time. This is one of those life situations that somebody just really fell on hard times. So, we would encourage you in those situations to try to offer some home retention option. I have a thing. I don't foreclose on single moms, right? I just, it's my thing. And I don't foreclose on the elderly. And the reason being is I actually did foreclose an elderly couple. And the sheriff called me and he said, there's just no way I'm evicting these people. You need to call social services and relocate them. So, it's something I didn't listen. I was early in my career. It
Mhm.
wound up costing the client a shit ton of money to get them out. They told me very upfront, hey, we're this age, we both have cancer. The sheriff's
Oh.
like, I'm not even going into the house.
Mm-mm.
Right.
Yeah.
I mean, understanding that when you're foreclosing in a small town in America, that sheriff probably even knows those people.
Mhm.
So, when in Ohio, when they had the freezing temperatures, we would try to do evictions. The sheriff's like, where am I going to put them? I'm not displacing, these people during the weather time. And so you're kind of sitting there like, man, what do I do now?
Right. And
Nothing.
exactly. And quite frankly, you're in California and I'm sitting in Dallas, so I don't even think about the fact that it's 10 degrees out in
Exactly.
Ohio. It's not. So yeah, I could see setting that up and getting that call from the sheriff because you just
Right.
don't
So
think about it.
understanding that, hey, this is somebody that has a real life situation. And if they were my neighbor and, maybe my ideal payment's $400 a month and they only could do 325, you know what? I'll take the 325 because if I actually have to evict them, right? How long is that process going to take? It's
Mhm.
in Ohio. It's cold outside. They're elderly. They have family. They have nowhere to go, right? I'm going to have to store their personal property for a period of time, right? Do I want to deal with that? What's the condition of the house? I mean, we like to do walkthroughs of all the houses. There's nothing worse than you had the opportunity for a mod, you gave it up because you wanted the house, and then you open the front door, as and it's like, what can I do with this place? It's a tear down.
Mhm.
How could somebody live there? Well, somebody was living there.
It's better than living under the bridge. I mean,
Exactly. Right.
well, what I've often done is if the borrower reaches out and they want to work with me,
Mhm.
I'll have them take pictures of all four corners of every room in the house. So I have some
Right.
idea of the condition of the asset before
Yeah.
we get anything started.
A lot of the property preservation companies, or even if you just call a local real estate agent, they'll do a quick walkthrough of the house.
Yeah, I have found the borrower doesn't really want to let anybody in. They're not sure who I am, so the idea of me
Right.
sending vendors there. So if I just have them take the pictures, if they really want to work with me, then they're
That's
really going to
smart.
do it.
Absolutely. Yep.
So, and
I
you
mean,
have to
now with
ask for
social
all the
media,
corners.
you can do a FaceTime. You can do,
Hmm.
there's a lot of things you can probably do that, they can easily take pictures and text you,
Yep.
respond that way. So
Yeah.
absolutely.
So that way you get more information on what you're dealing with. So,
Yeah. I mean, I'm a victim of that. I've been very aggressive with some properties and I foreclosed and I get them like, why in the world did I foreclose on this house?
yes.
I mean, you can push a borrower only so much.
Hmm.
And eventually they'll just say, you know what? Here you go. Come get it.
Yep.
And when they say come get it, there's something wrong with that house.
Yeah, they're chuckling at you.
Yeah,
Definitely.
nobody gives up, a substantial amount of equity in a nice house on a golf course in La Jolla. That just doesn't happen.
Yeah, I don't think I'm ever foreclosing on that beach house I want. I just
No.
don't see it. it's a dream, and you got to dream, but it's
Right.
not going to happen.
Yeah.
All right, cool. So we have at least one question for you at this point. Okay. Charlie asked, does your firm have a minimum portfolio size or number of notes that an investor would need to have to work with you?
Yeah. We try to usually do a minimum of around 10 loans. But, look, we're open-minded as well. So, we'll get clients that are looking at a portfolio or they've just bought one and they're looking to scale up. And so, we'll certainly entertain, that client. What we try to avoid is a client that has one loan. They have no intention of ever buying a single loan. They just really want to get it to perform. They're never going to foreclose. That's not the shop we're not that shop.
Yeah. I technically don't think many people would want to be that shop. It's just, you want to build a business relationship. So.
Exactly, right? I mean, we want to help you in the business. I mean, we want to show you what the opportunities are in terms of, hey, look at if I really am able to liquidate this and see these kind of returns and realize, that business model that I created, there is scalability in this industry.
Okay. All right. If anybody else has any other questions, please feel free to post them in the chat box. But I'm going to ask Daniel a couple of questions about
Sure.
BK Seconds.
BK
I was recently looking at a tape of Seconds.
Okay.
It was with a seller in the industry who everybody and their brother has probably sued at one point, but he's reformed himself. Things are going to go better. Whatever.
Right.
He had 400 assets on his tape, and
Yeah.
he said I had to buy at least 200. So I ripped through his tape. I found 60 I could stand.
Okay.
In the process of going through that, so many of them had filed Chapter 7.
Yep.
Now, I have to be honest, my experience with Chapter 7 is limited. I've had a number of loans where they started with a 7 and converted to a 13, and I've bought those.
Okay.
I've had borrowers file Chapter 13, but I've never had anybody file a 7 or work through a 7 while it was my loan.
Okay.
So I had never seen a Chapter 7 before that was a no asset foreclosure, and they were completely discharged out of.
So a no asset bankruptcy.
Yes, I'm sorry, a no asset bankruptcy, and they were discharged from the 7.
Okay.
What happens? They like
Okay,
my.
so you're looking, because you're probably confusing the word of asset as, well, they have a house, that's an asset.
Mm-hmm.
They have a car, that's an asset.
Mm-hmm.
They have some jewelry, some furniture, some TV, those are all assets, right? But the bankruptcy court doesn't look at those as assets.
Okay.
The bankruptcy court looks at it as, and it's really the trustee will say, if I liquidate that house, after I pay off all the secured creditors, is there anything left over for the unsecured creditors? And if the answer is no, it's deemed to be a no asset bankruptcy.
Okay.
If the answer is yes, it's an asset bankruptcy. So, for example, if I have a house that's worth $100,000
Mm-hmm.
and I have mortgages that are encumbering that property to $300,000, there's no way the trustee is going to sell that house because you're not going to sell it for $100,000.
Okay.
Put $300,000 on it. So it's a no asset case.
Interesting.
So look at asset as the equity above and beyond the secured creditors on the property. Now, there is situations where a borrower will have a substantial amount of cash. They could have jewelry, right? So assets that are not encumbered that a trustee will sell, and they're only selling them to pay off the unsecured creditors. So your credit card companies, your hospital bills, right? Which is why the majority of people file Chapter 7 bankruptcy proceedings.
Okay.
And I would say the majority of the cases we see are Chapter 7 no asset bankruptcies with a discharge. The discharge meaning you no longer have a personal obligations under the loans. So back to our example, you have a borrower that has a $100,000 house. He owes 300 or she owes 300,000 on it. The lender says, hey, I'm going to sue you after your discharge for deficiency judgment. Well, I'm sorry. That discharge prohibits the lender from coming after you personally.
Mm-hmm.
And I use the word personally, I emphasize it because that doesn't prohibit the lender from foreclosing on the real property, just pursuing an action against the borrower personally.
So in that scenario, they would still be able to go after the 100,000. They're
You
not
could
getting
still
to the
you can go after the house,
100.
right? You
Okay.
could repo the car.
Okay.
You can do anything on your real property to liquidate it. You just can't go after the borrower personally for it.
Okay. So what if we had that same scenario? The house is worth 100, but in this case, the first was 75 and the second was 25.
Okay. And again, if the trustee looked at that and says, well, there's 100,000 owed against it, 10% for real estate commissions and costs, and me, Mr. Trustee, or me, Mrs. Trustee, I'm not working for free. And so I want, not enough assets there for the trustee to go after it. But let's take that same example and say the first had 20,000 and you had a $20,000 second.
Mm-hmm.
Trustee would likely step in the case. It's an asset case, right? So the borrower still gets a discharge. You would still get a discharge for the borrower. So their personal obligations under the loans are forgiven. They no longer have a personal obligation to pay the loan back.
Mm-hmm.
But the trustee will then sell the property just like any real estate agent would. The trustee pays you off in full. You get your 20,000. The first gets its 20,000, and that $60,000 balance goes to pay off the unsecured creditors.
Okay. But
during the crash of the market, it was always non-asset sevens. Very rarely did you ever see. Now, as the real estate markets are starting to come back, borrowers are having some equity in their property. You'll occasionally see an asset case, but for the most part, they're all non-assets.
okay. But what about back to my scenario where it was a $100,000 house, 75 first and a 25 second?
Mhm.
The trustee wouldn't sell the house,
No,
so there's nothing to pay the unsecured people. But
right.
then what happens? I still have my lien interest?
Yes, you still have your second mortgage on the property, and the minute the discharge is entered and the case is closed, you would be able to foreclose, or you get relief from stay and you can foreclose.
Okay.
It's very common in seconds, and we get it daily. We'll get a call, hey, I got a letter from you, or I got your foreclosure notice. I filed Chapter 7 bankruptcy in 2012, and I included the loan. And we say, great, that's awesome. But you haven't paid on it since 2012. Yeah, I know, but my attorney told me that it was including the bankruptcy, so the loan was forgiven. No, no. Your personal obligations on the loan was forgiven, and I'm not going after you personally, but I'm enforcing my lien interest against the property. So if you want to stop the foreclosure, you got to pay.
And how does that nebulous period work in the middle? They're not personally responsible, but they want to stay, so they want to pay on the loan.
Right. Then they become personally responsible.
Do they have to do a reaffirmation, or
No,
they don't?
no.
Just by saying, I assume they'd have to fill out a loan modification.
Right. They would fill out a loan modification application. They would enter into a loan modification. Some states would require them to do a reaffirmation, or some states, we have a lot of clients that would require them to reopen their bankruptcy case, get the loan modification approved by the court, and then they'd be obligated to pay.
What benefit is it to reopen the bankruptcy?
For the lender, it's a big benefit because you get a court order that approves the loan modification.
Okay. All right. So
I
if
always tell clients,
Mhm.
what's realistically that you're going to go after a borrower for a deficiency action? Right? If they're losing their house in foreclosure, they probably have no assets to go after.
Yeah.
Now, you may buy something where it's a real estate investor or somebody rebounds, they get their life back together. But for the most part, unless you can identify that, pursue the foreclosure, liquidate the property, move on. Because even if there is no bankruptcy situation and you get the deficiency judgment, the minute you call them, they file bankruptcy.
Yeah.
You get a Chapter 7 discharge.
Yeah. But I think personally, I've never done a deficiency judgment. I would go after someone that was running some kind of scam, like renting the property out, but not bothering to pay their mortgage. And they had other properties to actually go after. And they would have to be difficult with me or never respond, or, there'd have to be a lot of things before bothering to do that.
Yeah. And again, that situation, we have one right now where the borrower is a strategic defaulter. He owns 15 some odd properties. So yes, in that unique situation, there's an identifiable asset that you can go after. And so maybe it's worth it. But for the most part, it's,
Mhm.
you know, they just fell in hard times. They can't afford it. And going out, spending the money to go after them on a paper judgment, it's just not worth it.
Yeah. Yeah.
And again, it's not uncommon to have a borrower you're foreclosing on a rental property that's, rent skimming.
Mm.
To me, that's not illegal, right? I mean, it's their
Mhm.
rent. You have remedies that you can pursue if you want to get a receiver in place and try to attach the rent. I mean, that's your choice. Um, Again, I think it's just move those things to foreclosure. Keep in mind, in a lot of states, to get a deficiency, it slows down the process as well. So you have to make the decision. If I want to get the deficiency and pursue that, is it going to cost me an extra 2 or 3 months? Or would I rather just foreclose, get the rental income, right?
Hmm.
Stop the borrower from capturing that rental income, and then just moving on.
So why I've never heard of the deficiency judgment slowing down your foreclosure. I always thought you did the foreclosure first and then.
No, every state is different.
Oh, interesting. Interesting. All right. Well, that makes it even less likely that I would go ahead and do that.
Every time, and we have a lot of attorneys will say, do you want the deficiency judgment or not? And if so, it's going to be this, and I say, just waive it. It's just not worth it.
Yeah. Okay. All right. Another question. Can you talk about any new state regulations, such as all the changes that they did in Ohio, and any others that you're seeing?
Right. Well, Ohio, the big change if you're a second lien buyer. So the statute says that if you're a second lien buyer, you're now required to be registered with their Department of, I think it's Financial Affairs. And then the breach notices or their communications has to include specific terms that the state is now requiring. So those are the two real big changes in Ohio. Really now the big changes, not really necessarily changes, because, for example, Georgia has always had a debt buying license requirement. And I'm going to say this sort of as a disclosure. I'm using the word debt buying license because some states require you to have a collection license. Some states say it's a servicing license. Some say it's a debt buying license. So I'm going to just generically say debt buying license, right? So if you find out that Washington is actually a servicing license, don't say, well, Daniel said it's a debt buying license. But states like Illinois, Georgia, they've had those rules in effect for a while, but there's just been no enforcement of them. But now they're enforcing them, right? So the
Mhm.
states have realized, look, and I can make a ton of money if I'm in Washington and you need to register to foreclose or, to buy loans, you got to register. So Washington, um, Maryland had some recent litigation where at one point it was you didn't need a license, then you needed the license, and now you don't need a license again. So, we're watching Maryland. Ohio now has that registration. It's not a license, it's just a registration. But there's about 10 plus states that on the books, you're required to have a license of some kind to do business. Also, keep in mind that I think Indiana, Ohio, are you required to register your business in those states to do business in those states. The
So
best
what?
suggestion for new rules is if you're in Ohio and you're buying loans in Ohio, reach out. You can reach out to us. We'll introduce you to our attorney. He'll say, yes, in our state, you need X, Y, and Z. Best is to do it before you buy the loan, right? Because you never want to get in a situation where it's, hey, I just bought a loan in this state. And it's like, yeah, well, you needed to do all these things. It's like, well, I'm not spending the $5,000 that I need to get registered in that state to foreclose. Well, you know what? You're not foreclosing then, because we've gone through some issues where we started foreclosure and the client wasn't licensed, and the client got sued, and everybody got sued. So now we'll tell you, look, at congratulations on your purchase, but until you get licensed, we just simply can't do anything for you.
Yeah. Well, note investors are historically very cheap. So I can totally see people going, well, why would I spend that until I
Right.
knew I needed to? If I don't get the loan, then I don't need the license. So
But understanding that the consumer bar, right? So the consumer attorneys out there, they're going to figure it out. And what they'll eventually figure out is you can walk down to your county recorder's office, you can find those recorded assignments, and
mhm,
you can live in Georgia. And you'll say, oh, whatever, entity, X, Y, and Z, no buyer,
mhm,
they've bought 40 loans in this state. And you look and it says, well, they don't have a license in this state. And they go knock on those doors of those 40 homeowners.
mhm.
And sure enough, they'll tell them, hey, you want to make a quick buck?
Oh, yeah, absolutely.
And who do you think they're going to sue? You.
Mhm.
And
Mhm.
what's your defense?
I didn't
Uh,
know. I didn't know.
the I didn't know it doesn't work,
No.
right? I'm sorry.
Mhm.
Just get ready to write the check,
Yeah.
right? So yes, it may be cheap to be smart to be cheap. Well, though I'll fly under the radar. I have 5
Mhm.
loans.
Yep.
Somebody said at one time there's an exemption. I think I'm entitled to that exemption. I'm good. Okay, no problem.
Well, could you, and yes, it's me trying to be a cheap note investor. Let's say I buy the loan in the place I have to have the license.
Yeah.
I get my assignment, but I don't record it. I go get my license, then I record my assignment, and then I go ahead and foreclose. Would that work? Because I don't have to
Okay,
spend the money till I have the loan.
I always say at the end of the day, you're going to have to answer to a jury or a judge,
True.
right? Could that be a defense? Maybe, right? Can you convince 12, 9, whatever reasonable people that that's your defense? That I didn't really buy the loan, right? Although my purchase and sale contract said that I was the owner of the loan, right?
Yeah.
Because I didn't record that assignment. I'm not sure it's worth the risk nowadays. I think if you have identified, for example, that, hey, I'm really going to buy a lot of loans in Georgia,
Mhm.
Georgia's going to be my state, I'd take the effort and go out and get licensed. The investment, the initial investment plus the yearly maintenance fee, it's just worth it. Or don't buy in Georgia,
Right.
right? Just say, look, I'm not going to buy in these states because the risk is too great. And there's ways you can structure your corporate entity to potentially get out from the licensing restrictions. And there's plenty of firms out there that can assist, debt buyers on how to, avoid the licensing requirements and the best way to structure your corporate entities. And I'll stop there, right? Because I know enough to get myself into trouble. So,
Exactly. And you might
uh,
as well spend all those legal fees just getting your license.
right. I mean, the point is that as you're getting into the business, and if you've solicited money or you have money and you're, just be smart. Other than, I really like the asset because it has a good BPO value and it's,
Yeah.
it's a nice house. There's a lot of other issues that arise throughout the process, such as, did I structure the deal correctly? Do I need any sort of licensing, et
Mhm.
cetera, et cetera? What are the foreclosure fees and costs? I mean, there's a county in Ohio, and I can't remember that you have to put up a foreclosure bond of $10,000 on any house that's vacant that
That
you're foreclosing on.
Youngstown? I think it
It's
might be
Youngstown
Youngstown.
and one other one.
Okay.
I
Yeah.
mean, if you're buying a house there and it's vacant and you don't know that,
Oh,
like, there goes your whole profit. Like, that's
mm-hmm.
gone.
Mm-hmm.
Right? So those are the kind of things that I think we as a firm can assist with because, we'll put you in contact with our attorney in Ohio, right? And say, hey, here's, we use Dan Cox. Dan, tell me all of the pitfalls here. And they're all willing to say, yep, here's what's going on. Here's what you need to do. We have foreclosure bond. You got to be registered. You got to be licensed. You don't need to be licensed. You don't need to be registered.
Mm-hmm.
And then you can just, add that into your due diligence, add that into, hey, I'm going to need to set aside $10,000 for my foreclosure bond. New Jersey has weird tax restrict. I mean, there's a ton of things. I know Pennsylvania has a new one. If the borrower dies and there's no heirs, the lender is potentially responsible for the estate tax.
Are you kidding?
Right. So these are all these issues that it's just important to kind of know in today's climate what you're really getting into.
Yeah. My biggest disaster deal was in Pennsylvania. I don't care what they do. I'm never investing there again. And they could be giving away houses for free.
Right.
I'm not doing it.
Most of the disasters I deal with are not because they're asset related. It's because there's some legal issue that the investors just never anticipated.
True. True. Mine actually sort of was. I won't go through the picky part of the detail, but the hedge fund was getting ready to foreclose. They're going to foreclose in 2 weeks. So I had to pay the delinquent taxes so that we'd get a deed. So I paid the foreclosure company, and 2 days later, they closed their doors. They filed for bankruptcy, fired all of their employees, and stopped returning all calls and all emails. But I didn't have any kind of standing with the county to find out what they did with my money. It was a disaster.
Yeah.
So yeah.
If you really sit down and you read those servicing comments, and I tell this on almost every webinar, every client I do, if you're not reading the servicing comments, not the servicing pay history, the
Right.
comments, right? The comments gives you so much information about the borrower, the tax issues, the property condition. I mean, when people buy them with even Adam, I mean, it's foolish because it's unfortunate. By the time once you buy it, what you discover after that, it's just too late.
Yeah.
We may be really good about moving foreclosures and we may have great outreach, but a bad buy is a bad buy.
Mm-hmm.
You know, there's nothing that we really can do to turn a bad buy into a great buy. Does it happen? Of course. But if the house in the servicing comment said was vacant and caught on fire and the fire department cut a hole in the roof and didn't patch it up, and then it was 3 weeks of torrential rain, what can I do?
Mm-hmm. I got all the signatures in the right place, but that's not gonna help.
Exactly, right? I can move it to foreclosure promptly, but that's about it.
Yeah. Well, it's similar to a traditional real estate investment. You make your money on the buy. You know, you can screw it up on the sell, but if you've screwed up the buy, you're in trouble.
Right.
So, yeah. All right, we got another question for you. What are the costs of a debt buyer license in Ohio?
The answer to that question is zero, because I said it wasn't a debt buyer's license in Ohio. You had to register with the state of financial affairs.
What a very lawyer-like answer
Right.
from you.
That's right.
So how much do debt buyers licenses?
They range, right? They range. And, you know, my response is there's several firms out there that I would just hire and just say, hey, you handle it, right? Because the range could be from $500 to $5,000. And it's not that the cost is significant. I mean, that is a significant cost. It's the process to get licensed that's the hassle, right?
Okay.
And so you want to get it done right, because with every state agency, you know, they work at their own pace. And if you fill out application incorrectly, if you don't really know how the process works, one, it could lead to other issues that you don't want it to lead to, or two, it could lead to just months and months of delays, to a denial. So there's a ton of firms. I can email them to you that I'd recommend that you just, you know, again, if you're buying a lot in Georgia, call them up, get a license in Georgia. They'll handle everything for you.
Well, that's great. I think that would be a great resource. Okay.
We have a case now where the gentleman foreclosed in Illinois. Well, Illinois has a debt buyer license requirement, right? And they didn't have a license. Sorry, we don't have a license. Filed the lawsuit. We'll pay the fee. $20,000 attorney's fees. Why do you justify that? That's our attorney's fees. If they would have just gotten the license, it would have cost far less than $20,000.
Wow. Wow. All righty then. Yeah, that's a little scary. Okay. So if you go on Facebook in all of the various note investing groups, I of course have one, everybody and their brother will give you advice. Where's the best place to go to find out which states you need to be A, licensed in, and B, which license it is for that state?
So if you go to, you know, again, if you're at a firm that specializes in license, they'll tell you, I mean, for the most part, they'll give you a matrix and say, yep, here are all the states, right? And the matrix can be a little vague in general as to, well, we think it's this. But for the most part, they'll give you a matrix as to what you're going to need.
Okay. So when you were talking about firms that specialize in getting you the license, it's not one firm that'll do Illinois and one firm that'll do Georgia.
No, there's firms that they'll do across the country.
Oh, that's awesome.
And there's also non-law firms that'll do it too. There's a group here in Orange County that does them. You know, so there's non-lawyer companies out there and they'll send you the matrix, and you know, it's a quick questionnaire. You fill out what you're looking for, and they'll send you the matrix as to what they're going to need.
Okay, that'd be great if you send it to me.
Stuff on Facebook, a lot of it is just the non-lawyers being lawyers.
Oh,
right?
I know.
Saying, oh, you know, here's my legal advice. You know.
Well, how about the guy that goes, well, my attorney told me. So that's legal advice then. It came from an attorney, right?
And I mean, I follow all of the groups, and I never give it. I very rarely give advice other than to say, call me.
Yeah.
Send me an email.
I've seen you do that many times.
Right?
Hey, I'd love to help you.
I'm not giving advice because somebody will pick up that advice and they'll run with it and they'll say that was the bad advice and I relied on that. Again, and I preach this, you know, using our network you can call me, email me, and just say, hey, look at I heard you on the webinar. I'm buying a loan in Florida. You know, tell me what I need to be concerned about, generally speaking, and we'll respond to you. Or we'll say, hey, here's our firm. Reach out to them directly, and they can assist you.
And, a shameless plug for you. I have to be honest. I've used probably 6 or 7 attorneys in your network, and they've all been fantastic.
Right.
I have yet to go, meh, with any of them.
Right.
So it's,
and I should say it's not my network, right? I'm part of a network. And so, I mean, George Caballero's created the network. He's a big note buyer. He's been a long time practicing attorney as well. So these have all been vetted by, others than myself as well. And, we're constantly adding new quality attorneys to the network. So there's not many states that we don't have coverage in, unless you're buying in probably Alaska or Hawaii. And don't buy in Alaska or Hawaii.
Why? Because you don't have an
There's
attorney
one
there?
law firm, I think, that does Hawaii, who's the worst lawyer ever. And it's expensive and it takes a ton of time to foreclose. And I don't know anybody that buys in Alaska, unless you live in Alaska. I know nothing about the markets in Alaska.
That's interesting. That almost sounds like a challenge.
You try to buy in, I try to buy in populated areas where there's a lot of foreclosures and a lot of law firms.
Yeah. There's a lot of moose in Alaska, but I don't know if that's going to help you much.
Yeah, and it's hard. You have to try to find competent vendors, right? It's not just lawyers. You got to find the BPO, the real estate agent, the contractor to fix. And, and if you're in a community that doesn't have a lot of that, good luck.
Yeah. And whenever you never want to be the first person that trains the market how to do what you do. That's
exactly.
Just too painful.
Again, I'll get a client that lives in Florida and says, I found a great opportunity in Bozeman, Missouri, or Bozeman, Wyoming. I'm like, well, what do you know about the market? I know nothing about it. But it looks like a nice house on Zillow.
Exactly. So why is it a great opportunity? Yeah.
I understand if you're a bigger buyer, of course, as you know, sometimes you take the good with the bad, and sometimes you're forced to take areas that you have no relationship with. Yeah. But if you're getting in this business, it really helps to stay regional, right? If you can jump on a Southwest Airlines flight and be there in 2 hours, you have a local real estate agent, if you know the communities, if you have some ties to it, it's an advantage because you know the markets better than most. You know what's appreciating, you know what's depreciating, you know that there was a local business that, manufacturing company that went out of business 2 years ago. And it's unfortunately, it's a dying community.
Yep.
That's the stuff that I couldn't tell you sitting here in, Southern California.
Absolutely. Absolutely. And once you've built these relationships there, when something happens, like if there's rumors going on that the plant's going to close, you'll find out about them before other investors because you have relationships with your team there.
That's right.
So definitely. You have to invest your time in your team.
Right.
I agree. All righty. Well, I don't think we have any more questions in the chat room. I think we're good. Thank you very much.
No problem. Thank you.
This is always awesome. Take care. I hope I see you soon, by the way.
I hope so. Tell Jackie hi.
Okay. Take care.
Bye-bye.